Henry's a legend in the in our seminar, as you well know. I'm going to get his bio up here. But Henry's a low country attorney. He's also, I first met him at a gun show. He was working with the ATP gun shop down there, which is a huge gun store down there, and they travel around to the gun shows, and it said attorney on his shirt, and I was really impressed that this gun shop actually has their own attorney. And
I do some contract work for them.
Okay.
Good paying client.
Oh, there you go. All right, here's your bio. So I'll shut that down in a bit, but go ahead.
Okay.
Thanks for coming out.
Well, hello? Okay. Can you all hear me okay? Yeah. Good. All right. I didn't want to be too loud. Yeah, it was, got some good news and some bad news. The good news is we've got a lot of very talented speakers up here today, and last week down in Charleston, a lot more than we've had in the past that have joined the group. But the bad news is we've got to divide time, and you won't have me for a full hour. You'll only get me for half an hour, so I'm sorry. But the good news after that is we run right into lunch. Now, while I think one of the people were talking, I got a call from the people who collect tolls down in Hilton Head. My firm gave me a week down in Hilton Head we had a vacation timeshare, and they said, Henry, you want to go down to Hilton Head for Christmas? I said, sure. I took my boys down there, and we had 2 cars. Well, if you're familiar with Hilton Head, I think it's the only place in South Carolina where you pay toll. As you come across a road, if you want to take the shortcut, you pay toll. It's like $1.25. It's not really very much. Well, so I paid that. But there's a long way around. You could go that way, and it's maybe adds 5 minutes to your drive. My boys, they're from Charleston. They don't know about toll. I'm from someplace near where Mary is from, in South Philly, where we have tolls. So they didn't know about toll. So they saw the one where you don't have to pay. It says Palmetto Pass. They said, oh, Palmetto Pass, that must be for people from South Carolina. Everybody else has to pay toll. So they just kept going through. Every time they went through, the machine took a picture of their license plate. Next thing you know, I get a bill in the mail for like $16, and 10 of that was not toll. That was the administrative fee for them having to send me a bill. Then I got another one the same day. So that was $20 on top of the $4 more of toll, and I got after I paid that, and I sent a letter apologizing and a check, and I got another one, and I called them to make sure they got the last one. Yeah, these are more tolls. Apparently, they just kept zipping through every time they want to go fishing. But since I had her on the phone, she called me up today, and she waived the $10 admin fee, and I just had to pay the $3.75, and I used a credit card. She said, that's the end of it. If you get any more, call me. We'll take care of it that way. So all's well that ends well. So I wanted to talk to you a little bit about the new domestic violence law, among other things. If I can find it. It's in your materials. If you have that binder, there's an orange thing. I think it's right after the orange thing. It should be the new domestic violence statute. If I've got the color wrong, I guess they won't let me fly anymore if I can't tell colors. But if you has everybody seen that? It's really hard to find online. I don't know if it's even been published right yet. But I had to have my assistant, who's out of the Charleston Law School, go research it and find the new statute. But it is in effect. So the significance about domestic violence laws to people who are, I guess, concerned about guns like us is everybody knows the old 1968 Gun Control Act. If you have a felony conviction, convicted felon can't own a gun, right? Can't own or possess firearms or ammunition. But back in the 90s, the law got changed that if you are convicted of a misdemeanor crime of domestic violence, even a misdemeanor, you cannot own or possess firearms or ammunition. So that's the rub. A lot of people don't realize that, and if you are representing somebody who, most people in South Carolina value their hunting and fishing, and, they grew up with guns, and they're offered if you're representing them, and they're offered to take a plea in a domestic violence case, you might think it's, well, just attend some classes, and we'll waive the fine or pay some admin fees and no jail time. Well, they just lost most of their hunting and fishing rights. I mean, they can still go hunting or fishing, but they cannot own or possess firearms or ammunition. So now every firearm they still own, they're now, basically a felon. So you have to be aware of that. The new statute changes things somewhat. There's actually a little gouge in there that points to most of the changes. I think it's at the very end of the handout. Maybe it's at the beginning of the handout. I don't know where they put it in the book, but it's in there. It's got a little gouge that tries to highlight the changes. But the changes are basically the graduations of the offense, what constitutes the offense. They just reworded it. This is a big change. It's now no longer called criminal domestic violence. Now it's just called domestic violence. A couple of weeks ago at the bar convention down in Charleston, one of the legislators that was working on that bill said, well, we just wanted to recognize that domestic violence is criminal. It doesn't have to be like there's criminal domestic violence and other domestic violence. No, it's all criminal. That's why they did that. It's to make an acknowledgement. Not really substantive in so far as what it did, but they wanted to recognize that. The penalties, they have CDV hand, and they have CDV first degree, second degree, and third degree. Third degree is basically the misdemeanor crime of domestic violence that we have always known. But the maximum penalty for that is now up to 90 days. And it's triable both in circuit court or in magistrate's court concurrently. Another thing that the new statutes do is it actually criminalizes possession of firearms or ammunition for people convicted of CDV. Before, that was a federal law, but it wasn't a state law. Now it's a state statute. So if you, I guess that gives law enforcement the right to go in there and make a state charge. Before, the police could always come in and, if they could report you to the ATF, and the ATF could decide whether they wanted to bring a case after they consult with the U.S. Attorney's Office, and the U.S. Attorney decides, is this someone we want to make a federal case over? And, they basically teamwork it. But now we can do it at the local level. Solicitor can prosecute you. Because they did that, there were people who didn't want to, a lot of politics, and, well, okay, we'll vote for this. We'll agree to go along with you making that criminal, but we don't really want it to be, so what can we get out of it? So a lot of compromising back and forth, and here's what they came up with. Let's see if I can. Looks like 1625:30, and then there's section B. Yeah, B. C, here it is, C. A person must not be considered to have been convicted of domestic violence for purposes of this section unless the person was represented by counsel in the case or knowingly and intelligently waived the right to counsel, and in the case of a prosecution for an offense described in this section, which the person was entitled to a jury trial. Basically, it just says he had to knowingly and intelligently waive his rights to a lawyer or have a lawyer present with him. So if all that wasn't covered, he's got a good case for the fact that it shouldn't count as a conviction for firearms purposes. Yeah. The other thing is they put durations for the prohibition of firearms. If you are convicted of CDV hand, the ban is in effect for 10 years, or first degree, 10 years. 3 years for if you are convicted of second degree or third degree, the ban is in effect. That's in the handout. Don't worry about remembering this. You can read that statute for yourself and get familiar with it. I just want to point out some of the high points because I've only got a half an hour and there's a lot to talk about. So please don't feel lost. I just want to point that out. You'll certainly read the statute, and there it is. Now, here's another thing. This is very interesting. Here it is. After the period has run and there have been no other domestic violent offenses in the interim, whatever the period, we're talking about the 10-year or the 3-year period, if during that time there have been no other convictions for domestic violence, and at the end of the period you have no such charges pending, then you are not considered to have been convicted of domestic violence for purposes of firearms under state law. And if you write to SLED and ask them to do so, they will notify the people who run the background check computer, the FBI, National Institute Check Computer, and notify them that your rights have been restored. You have to write to SLED, ask them to do it, they have to research it out, and then write the letter. You have a question? Yes, sir.
Does that apply retroactively?
I'm so glad you asked that question, because that's right what I was about to talk about. If you read the statute, it doesn't say that. I happen to have a client who came to me a few months ago. He was referred by a certain gun shop that he apparently tried to buy a gun and was denied. The reason he was denied is because he had, among other things, some out-of-state charges which were disqualifying in another state. So I can't do anything about that because I don't practice law. Hang on, let me finish this. And but he also had a like a 2007 conviction for under the old CDV statute here. He passed his 5 years and he had that expunged. Meanwhile, the state in which he was convicted, that out-of-state, northern state, whatever it was, allowed him to get those charges off his record because they were a first offense. So they had a very liberal view of allowing him to purge his record. So ultimately, he has a letter from Nix on his appeal that says, well, it looks like you've taken care of the out-of-state charges that would have been disqualifying, so they're no longer disqualifying. However, we want to point out that under South Carolina law, we no longer consider expungements to be pure expungements, and that's we're wondering what they mean by that. Is it because SLED's allowed to maintain a non-public copy or record of it? We really don't know what they mean. But I said, you're in luck because under the new law, we are allowed to write SLED and ask them to notify Nix that your rights have been restored. So that's what I asked him to do, and I've been communicating with the SLED attorney, and he says, Henry, let me get back to you on a nice young man, Adam Whitsett, if you've ever dealt with him, very, very personable, easy to talk to, very forthcoming, a gentleman. If he says he's going to do something, he does it, doesn't backdoor anybody, practices law the way it's supposed to be practiced. I think he went to USC School of Law, by the way. Anyways, I've got nothing but praise for him, but I'm still waiting for him. And he says, Henry, this is our first case. Nobody's ever asked us to do this, so we're going to have to let you know. I just wrote him a follow-up letter before I came up here to ask him what he's decided to do on that. It may be that we'll just have the person go back and apply if everything else has been purged. The background check should go through, and we don't need to worry about it, but I'm just waiting for some follow-up from him. So that's the answer to that question, the gentleman on my left that asked that, and then you had a question. Yes, sir.
Well, I just want to know if you send donuts to this gun shop.
What I do is if somebody brings donuts to the office, and they do sometimes, we're not big donut eaters at the office, and I would be if they brought the right kind, but apparently I'm in the minority. I like jelly donuts. If I don't get jelly donuts, you know, I'm just not interested in the other ones. But I do bring the donuts to the gun shop, and they're not there very long. So if there are any left over here, I will probably bring those back to the gun shop this evening or tomorrow, and I'm sure they'll be gone in very short order. Thank you for that. Anyways, I think that's a huge thing that, because if you think about it, the federal statute prohibits people who are convicted of domestic violence from owning or possessing firearms. But now by state statute, I think we're affecting that statute because we say we don't consider you to be convicted under state law after so many years. So, and you can have your rights restored. So that's really maybe one step backward, two steps forward, depending on which camp you're in. So take a look at that statute. That's really, really big. Also requires bond hearings to be held in 24 hours. On the one hand, the statute says, yeah, notwithstanding any time provisions, we want the police report there, the record there, or we want the officer there for the bond hearing. Then in the very next sentence it says, but we want the bond hearing held within 24 hours, regardless. So read that as you will. And the rest of the statute is all in there. Now, there was some talk the previous lesson by previous presentation of Castleman. There's another prior U.S. Supreme Court case which is prominently featured in Castleman, and that's U.S. versus Hayes. And in the Hayes case, I think that was 2009, my understanding, the way I read that is, even if you were convicted of something other than domestic violence, if the same elements were there, or if it was against the spouse, even if we called it assault and battery, if it involved you assaulting somebody who was a spouse or a girlfriend, a boyfriend, somebody with whom you were intimate or lived together or have a child in common, and or you used a violent weapon in the process, or deadly weapon in the process, rather, we're still going to consider that a misdemeanor crime of domestic violence, even if that's not called domestic violence, even if it's just called assault and battery. So I think the implication from that is, those of you who are representing people charged with domestic violence, you get offered, how about a plea to assault and battery third degree? Well, I think for sure if you take it as a lesser included offense, you may run afoul of the Hayes decision and subsequently Castleman, and you could still be under a prohibition and may not know it. Somebody wants to come back and make a case against you because you come to their attention, the government's attention later on, you've got some liability out there. It was asked of me in a previous case, well, what about if you dismiss the old ticket or warrant and do it on a new one? And I said, I don't know, maybe. We don't have that case yet. When we have that case, I'll know, but it's something to think about. Be aware of that. Now, that's not all. Where is that? We like to keep up with things, and things don't always go to the Supreme Court, but sometimes they go to the Court of Appeals for the Fourth Circuit. And this isn't in your material, so you might want to write this down. If Steve had given me a chalkboard with chalk, I would do that. But I don't use PowerPoints or projectors or any of that fancy stuff. I've been involved with people too many times, and they get their PowerPoint gets stuck. And I think the first time I did this, I was riding up to Greenville with another member who's not here today, Dr. Rob Butler, who a very, very passionate advocate for firearms rights. And he said, well, Henry, do you have a PowerPoint, or what are you doing? I said, no, I just have some stuff written down, and I have some materials. I'm just going to get up and talk about it. He says, well, it wouldn't take us very long. I can do your I got everything here. I'll put all your stuff on PowerPoint for you. I'll put it on the computer. And I said, oh, well, that's okay. I'll just talk about it. I'm not really, you know, it'll go easier for me if I can just talk about it. Well, he went up there and something went wrong, and he had to have one computer to project it on the screen and another computer to read. He had to use 2 or 3 computers, and it was just awkward. He couldn't really, he was locked in. He was landlocked. It was just bad. He did an excellent job with that, and he had great material, but just the technical stuff threw him. I remember another time I got asked by the FAA to go talk to some pilots about aviation safety. I used to do that, and everybody was asking me, well, Henry, are you going to want a room? You want with PowerPoint? Said, no, just give me a blackboard or a chalkboard or something with a grease pencil. I'll bring my own handouts. I'll just talk to everybody about it. And they couldn't believe it because they're all, you know, in the modern 21st century here. And, they couldn't understand that. Well, of course, they all had technical glitches, and I had to get my little Leatherman out because somebody had a plug that they couldn't get in. Some prongs were bent, and with this, they were able to unbend everything and get their thing going 45 minutes late. And, you know, I just don't want to rely on. One day, maybe I will, but not today. But write this down. U.S. versus Vinson, V-I-N-S-O-N. It's United States Court of Appeals for the Fourth Circuit, decided in 2015, and I don't have the site, I just have the number. Opinion number 14-4078. 14-4078. It has more than one Vinson case. This is kind of odd, and they're interpreting basically the applicability of Hayes. But apparently it comes out of North Carolina. Somebody was convicted of assault and battery in North Carolina. The district, and then he had possession of firearms, and they made a federal case because they thought it had elements of domestic violence. And for whatever reason, they wanted to prosecute him. It's not just because he had a gun. It's probably something that he did, you know, to come to the attention of the federal government, and they wanted to make a case against him. But the district court dismissed the case because it didn't think he met the test. It got appealed, and the Court of Appeals at first decided that, no, he met the test. They reinstated the charges. Then the lawyer got very creative, and he re-argued it so artfully that the Court of Appeals decided to rehear the case and change their mind because they didn't want to leave in place an erroneous interpretation of North Carolina law. They said, even though it wasn't argued below, it was argued for the first time on appeal, we're not required to not hear. We're going to, you know, we normally don't hear these things, but that's prudential. It's not jurisdictional. That's the wording they use. We're going to rehear this thing, and they decided that because North Carolina will allow a conviction for assault and battery based on something that wouldn't normally be criminal, a negligent act or a reckless act could lead to a conviction, could underlie a conviction based on their case law in North Carolina. So therefore, it didn't meet the statutory test to be a conviction, considered a conviction under federal law. So they threw the case out. But that's Fourth Circuit. I don't know whether it's been appealed or not. That was November 2015. I'll let you know next year if anything comes of it, but that's important. South Carolina, I think our statute for assault and battery third degree says an unlawful act, injure somebody by means of an unlawful act. So I'm wondering now if we have that case, is some lawyer's going to make the argument that, well, he could have injured him unlawfully by speeding and running in the back of him, and if he was charged, if he were later charged with assault. So therefore, because you could be convicted under South Carolina law that way, does that, you know, I don't know. I'm just making this up. It's first impression, but you know how lawyers are. You know, we reach for everything. So that's important. Now, back to the new domestic violence statute. That same bill that passed that also gave us permanent restraining orders. Last year, it was S3, Senate Bill 3, it was proposed. Now it's the law. But to be subject to a permanent restraining order, somebody has to be convicted of a crime, and the person seeking it has to have been a victim within the meaning and scope of the statute of some crime. And then they can move the circuit court at the time of the conviction or the family court at the time of the conviction or adjudication to issue a permanent restraining order. If it isn't done at the time, then you can bring an action for one basically in the circuit court, like in common pleas, you bring it like a civil suit. And the victim's name and information, well, the name will be there, but their address doesn't have to be part of the public record. They can use another address for receiving process, and their real address can be kept sealed. So that's in there now. That's in your handout. You should be able to see that. How are we doing on time? A couple more minutes? The people who practice in family court, y'all, how many people practice in family court here? Divorce, separation, custody, okay. Well, you know that state law allows us to ask for restraining orders against harming, harassing, and interfering, and they can be made mutual, right? You all know that? Yeah, doesn't have to be a ground for it. If you're in family court and you're going through a divorce or separation, the circuit court can grant, the family court judge can grant a restraining order and say no harming, harassing, interfering with the peaceful enjoyment of life by the other, coming about the other. You know, they can put whatever language they want in there. The statute prescribes some, and it usually tends to get really embellished when, you know, the lawyer's trying to think of anything. Because we all know we draft orders for judges to sign. Judges rarely draft their own. Even federal judges have law clerks to go draft them for them. Well, while you're putting all that in there, keep in mind that that restraining order looks a whole lot like another, you know, restraining order referred to in the federal statute that would prohibit somebody from owning or possessing firearms or ammunition if they're subject to such a restraining order, because it restrains them from threatening or harming or harassing an intimate partner, spouse, or child thereof, or someone with whom they have a child in common. So even though that wasn't intended, it was just intended to keep the people from fighting. You know, the lawyer's trying to protect their clients, and the other lawyer says, okay, no objection if we make it mutual. Both of them have restrained their clients, possibly from owning or possessing firearms. It doesn't go into the computer like the one issued under the Protection from Domestic Abuse Act, but it is a matter of court record, and should you come to the attention of the government for some reason that, you know, they decide, you know, you're somebody they're interested in and they want to target you, then that's some liability out there. So those of you who, you know, maybe been to another seminar, you may have heard this. I usually try to more artfully draft those restraining orders. I say, I don't have any objection to that restraining order, but let's word it this way. And then I say at the end, let's add this language. The court hereby requires that this is a mutual civil restraining order only and not one issued from any protection of Domestic Abuse Act or for purposes of federal or state firearms laws or the ATF Form 4473 or its successors. You know, if you've ever represented somebody in law enforcement, they're going to both come up and say, we don't want any restraining orders. No restraining orders. Read my lips. No restraining orders. Well, that's why they don't want it, because they're afraid they'll be subject to that law and they won't be able to work. They'll lose their rights to own or possess firearms, and they can't be in law enforcement. Can't go play anymore. So if you are representing people, you might want to think about that. I have some language I didn't put it in this handout, but I have some that I use. Sometimes other lawyers email me and say, what's that language that you're using? And I'll email it to them. And I'm constantly updating it to make it more and more innocuous for firearms. Even if you have somebody who's prohibited from owning or possessing firearms, you can still use that language because, you know, the use of that language to take it out of the basically the federal firearms prohibition doesn't relieve them of some other impediment that they have, but it might, you know, at least that won't add anything to it, and maybe the other party doesn't need the impediment either. Okay. Steve, what are we doing on time? I see it's 12 o'clock. Want me to go on, or? Okay, 4 or 5 minutes. That's, sorry? Okay. Does anybody have any questions about any of this? Somebody's got to, hold on a second. You, yes, sir. Could you please stand up so we can hear you? I can't hear you too well, I'm sorry. Oh, okay, the question is on the permanent restraining orders. That's the ones where, let's say, somebody's a victim of a violent crime or an assault of some kind, and they want to get a permanent restraining order against their victimizer. No, that's permanent. That's for life. No time, doesn't expire. There are restraining orders which expire, like the ones issued from under the Protection of Domestic Abuse Act. They expire, and when they expire, according to the law now says the prohibition against firearms expires with it. It's for the duration of the order. Of course, the ones that we get in family court, in those final decrees of divorce and separation, they don't expire. So, you know, choose your, you know, be careful what you ask for because you might get it. Choose your wording carefully. That's a good question. Thank you. Any other questions? Yes, sir.
Is there a way to go back and undo that family court order? Is there a way to?
Okay, so the question is, and correct me if I've misunderstood you, if you have gotten a restraining order in a decree of divorce that's not issued under the Protection from Domestic Abuse Act, it's just the usual suspects that seem to make their way into all of these orders. Can you modify that? I would think, I mean, I haven't had that case, but I would think that you could just file a motion, just like a motion for an increase in child support or something like that. I would try filing a motion. You might want to find out if the other person is still represented by counsel, you know, go through counsel first. If not, maybe write a letter so you can show that you've tried to do something before filing a motion, you know, Rule 11. But I'd either file a motion or I'd bring a new action for clarification from the family court that does not prohibit this person from, or was not intended to prohibit the person from owning or possessing firearms. It was simply gotten in compliance with the statute that allows for that. There's a statute. I didn't cite it in these materials. I'll look that up for you and give it to you during the break if you want it. That would be my suggestion. If you want to do that, I would also say that you might want to consider that while it's out there, it's not in a computer. So kind of like when I was thinking about going out to Oklahoma to go to law school. Everybody knows I'm a retired policeman. I asked talked to somebody from the police department that I ran into. I said, yeah, what about us, you know, retirees from out of state coming in here with guns? You know, how do y'all feel about that? And he says, well, Henry, the way we look at it is if you don't make a problem, there won't be a problem. So maybe it's that. If, you know, if somebody got charged, then maybe there's a problem. If your client is, you know, not really involved in heavy federal stuff or drugs, he's probably not likely to come to the attention of the government. They're really interested in only in people who are doing other things, and then this, maybe they couldn't get him for that, but they're going to get him for this because this was here and the other stuff was too elusive. They're not really looking to. It's not like they got somebody, you know, Officer O'Malley, who's going around looking for every little thing. You know, the aisles don't have enough room. There's only 14 inches. You don't have enough room between the aisles. We're going to cite you for a code. They're not really looking for that stuff. You have to come to them for something else. But yes, it's out there, and if it bothers somebody, that's the way I would approach it. Yes, sir. Thank you. It's a good question. Any other questions? Well, and I'd like to thank you for giving me this time. I really love coming up here. This is my favorite time of the year, even more favorite than Christmas, coming up here, being able to talk to all of you, and eating the barbecue. Thank you. Thank you.